please proceed.
This is case 2013-0885, City of Keene versus James Cleaveland et al. Mr. Bauer?
Your Honor, I request 2 minutes in reserve. As noted, I'll take 11 minutes. Brother Steve Buckley will be happy. Beakus will take 2, and I'll reserve 2 if needed. Thank you. May it please the Court. My name is Charles Bauer from Gallagher, Callahan, Trail, and Concord. I represent the City of Keene in this case. The 3 parking employees who are members of the City of Keene, Jane, Alan, and Linda, have all suffered work-related stress and anxiety due to the constant, proximate haranguing by the 6 defendants in this case, as alleged in the
Have they
complaint.
brought their own suits?
Pardon me?
Have they brought their own
No, they have not.
lawsuits?
Can I ask you?
That's an issue then, is the city's standing to bring a lawsuit based on their alleged suffering.
I understand, and if I may address that issue?
No, please.
That issue, the complaint, the petition that was filed before one of the employees quit his job because of the stress directly related to the conduct, the targeted conduct of the defendants. The petition to enjoin was brought in the first instance in order to prevent the workplace harassment and to protect the economic interest of the city in its employment relationship. Once we were going into this case, unfortunately, the lower court did not issue the injunction, and one of the individuals quit his job directly related to the conduct. Secondly, another employee, Jane, cut back her hours because of the defendant's conduct. And the third employee, Linda, has indicated that she's been considering filing a stress-related workers' compensation or disability claim. So there is standing by the city to protect its economic interests in the employment relationship as well as protect its employees in the workplace environment.
Well, its economic interest in the employment relation, I mean, I assume it does not have much of an interest in paying salaries. It may have an interest in the services that they perform, but what's its interest in paying salaries? I mean, if you look just narrowly at that seems to me to be more of a detriment. I mean, they're having to pay something out. If the claim is that the services themselves that they're providing are beneficial and that the city is being harmed in that regard, I can understand that claim.
No, Your Honor, with all due respect, no. It is not limited to the salaries. What it deals with is when there's an employment relationship, there's an investment of time, money, effort, services, but also the possibility and the potential, in this case, of people quitting their jobs because of unfettered conduct,
Well,
because of disability
we
claims.
have to even get to those issues, because if we agree with you that there needs to be some injunctive relief, then that should solve your problem. And I noticed that the area of protection that you're looking for apparently has shrunk over time, because your brief says what you really want is a reasonable safety zone, and in your view, that would be 15 feet or 2 parking meters. So if that's where we are today, if we just assume that we agree with you that some injunctive relief is appropriate, if we agree with you that the 15 feet, 2 parking meters is warranted in this case, doesn't that obviate all of your other claims? It should solve your problems, no?
It solves the most immediate and pressing problem on the streets, but it does not solve the problem of one employee quitting because of the unfettered conduct by defendants, that there was a breach, and there was an intentional or negligent interference with contractual relations, there was a conspiracy, and there was a negligence claim, all of which I should have gone to a jury for factual determinations.
Can I just ask you, if we accept this, your theory here, does that mean that the police officers in Ferguson, Missouri, have a lawsuit against, and I'm not talking about the protesters who were throwing things through windows or anything like that, but just the people who were protesting because they were angry about what happened, presumably getting in the face of many of the police officers. Do they have a lawsuit against the protesters?
I'm glad you asked me that question because it's a very relevant question, not only for the nation, but this case as well. I believe that if there's a track record of a constant in your face, the proximity is the key to this case, and it could be or would be in the Ferguson matter, the proximity and the duration. If it's an incidental in your face, if it's a fleeting moment.
Well, this is going to, but if I understand in Ferguson, it's gone on for quite a while now. I mean, would they have a lawsuit today or next month if it kept going on?
Would the police department or the city be able to obtain an injunction based on track record? And that's important in this case, based on track record, not in the first instance. We all know that oftentimes when there's a significant public safety, there are lines drawn. There is time, place, and manner implemented. And that's really what I'm asking this court to address.
And let me follow up on this. The time, place, and manner restriction, normally, most Supreme Court cases involving that relate to time, manner, place restrictions that have been enacted by the community or by ordinance. Here, as I understand it, that hasn't happened, and you're in essence asking the court to enact such an ordinance. We're not looking at the constitutionality of an ordinance. You're asking us as a court to create such an ordinance. That troubles me.
Well, I'm sorry that it troubles you. It shouldn't, Judge, because most recently, the United States Supreme Court, in the case of McLaughlin, said that this is the 35-foot buffer zone around the abortion clinic that was by ordinance, by legislative enactment, said it was too broad. What it said was, and it's quoted in my brief, that a court can tailor the specific injunctive relief to the specific individuals.
Sure, but
for the specific conduct.
The court eliminated the buffer zone.
Yes, it did.
Basically said there isn't going to be one.
It was too broad because they said they had less restrictive alternatives. And the less restrictive alternatives was injunctive relief. It comes, if I may, right out of the McLaughlin.
No, I've read it.
Okay.
And let me just ask you this about the injunctive relief. It's not clear to me. It appeared that the trial court understood the injunctive relief to be a remedy for the tort claims that were asserted. And my question is the request for injunctive relief a standalone claim? Or is it a function of relief because of the tort claims that you're asserting?
It can be both, Your Honor. It can be an injunctive action to prevent harm from occurring, so long as that harm is probable or likely to occur. But in this case, it went too far. Because the injunction was not issued, then there is a legal claim with regard to interference with contractual relations, negligence, and a conspiracy theory.
As I had it, you say that your client is not trying to suppress the viewpoints expressed,
Correct.
but only the means.
Correct.
So I take it that you would have the same position if, for example, take a different example, individuals were following these parking officers and continually screaming lullabies,
Oh,
so that they weren't expressing any particular viewpoint.
Right.
They were following, as you say, in very close proximity for an extended period of time. So you say it is that conduct. So you would be in here if there were people following your officers, screaming lullabies in their ear all day and waiting for them outside the bathroom to resume screaming the lullabies in their ears. I mean, you would be in here asking for the very same relief, I take it.
You're absolutely correct.
What if the police were, what if a group of citizens decided they wanted to follow the police around with cameras? They decided that they're going to just put cameras, you know, and follow the police around. Can we get an injunction against that?
Depends. There's an absolute right. It's the First Circuit Court of Appeals has said twice now in Glick and in Garret that there is a right to videotape not only police officers but municipal employees while they perform their jobs. However, it has to be done from a safer move. And the safer move is what I'm asking this court to allow.
Can I just ask what
That's what the trial judge got wrong.
Does the behavior here violate any municipal ordinance or any state law in your view?
It could, Your Honor. I mean, there could be some.
Well, are you asserting that?
It could or it does. Well, the bumping into, the touching is assaultive behavior. Now, is it, one of the questions I anticipated, well, why don't you just arrest them?
I was going to ask that. Go
I
ahead.
anticipated. The reason you don't arrest people is because we're not there to try to stamp out the content, the goal, the message. Arresting does that. What we're asking for is to please step back out of the face. Give us some breathing space. So, arresting is not the way to go because that's too onerous. That shuts down the content.
Thank you.
Now,
Good job, Sam.
thank you very much.
May it please the court, Stephen Buckley on behalf of the Hampshire Municipal Association, our organization represents 232 of the 234 cities and towns in the state of New Hampshire. Public employment is not a license for use by citizens. Public employment is not a license to employ invective or to invade the personal space of public employees. Trial court, from our perspective, did not adequately undertake a balancing of the First Amendment rights that are asserted by the defendants here and the public interests that the city has in protecting its employees from abuse.
Do you agree with Attorney Bauer that 15 feet or 2 parking meters, this floating zone of protection would be adequate?
I have to confess we did not participate in the case in the trial court, and I'm not prepared to say
Wouldn't that be a
necessarily.
judgment for the trial court to make anyway?
That's what I would suggest, and I think that's the problem with the trial court's decision. The court did not get to the point of balance in these interests. So I would have to defer to the city officials as to their decision-making and how they operate their parking enforcement.
So what you would say is that if we were to agree with your side of the case, a remand for that purpose would be in order.
Precisely. And I think that what we would argue is that the situation we find ourselves in is very similar to one that was found in the Chaplinsky versus New Hampshire case. In Chaplinsky, the party was brought to court for saying such things as goddamned racketeer and damned fascist. Well, in this case, the parking enforcement officers are being chased around, they're being disparaged, just demeaning things are being told to them. There was one occasion when
Well, yeah, but can I just ask you, let's put aside the perimeter thing, whether it's 15 feet or something like that. Are you saying that in addition to that, the injunction should be able to say, you know, the protesters or the people that are doing this shouldn't be able to say sort of nasty things to the parking meter people? You know, you're a bad person, you're, you know, whatever. You think of the appropriate invective, but that they shouldn't be able to do that?
No, I think my point is that in the balancing assessment the courts undertake, take into account the things that are being said and balance that against the means and methods that are employed by the defendants to convey their messages, and then craft relief which provides the buffer. All we're seeking is a buffer. We're not trying to control the content of the message.
Thank you.
Thank you.
Mr. Meyer?
Thank you.